of vessel homicide that necessarily precludes the jury from coming back with a guilty finding on the manslaughter. So I'm going to pass on that for a minute, okay? Then you're making a request for my further explaining what ordinary negligence is. I'm taking this as a separate special instruction. Like
Yes.
apart from the vessel homicide, the language you included, apart from the manslaughter language that you included, this is now another separate special instruction request.
Yes, please.
Okay. That ordinary negligence is not sufficient for a criminal conviction. Okay.
That's the title of our section.
That's the title of the special instruction. Okay. And then I'll jump back.
To be clear, we're not asking you to put the title in front of the jury. It's just to guide your review. It's the page that is titled "Ordinary Negligence is not sufficient for criminal conviction."
Okay, so as a special instruction, you don't want a heading?
If you'll give it to us, we'll take it.
Okay.
Yeah.
All right. State, do you know where I am on this?
Yes, Judge.
Oh.
And I would object to that instruction, Your Honor, because the standard instructions talk about that recklessness is requires the state to prove more than a failure to use ordinary care. So the jury instruction for vessel homicide, just like the jury instruction for manslaughter, makes it very clear that neither recklessness nor culpable negligence can be proven with simple negligence.
Cannot be proven.
Correct.
Okay. I'm going to decline to give the additional special instruction on further explanation of that ordinary negligence is insufficient to support a criminal conviction.
Understood. And to be clear, we would ask for each sentence to be considered alone and in combination, or let me rephrase.
Correct.
Each be considered alone. We prefer that they be given in combination, but we'll take as few or as many as the court will give us.
Look at criminal cases are different from civil trials. Any comment from the state?
Yes, one moment, please, Your Honor. Your Honor, that instruction is part of the instructions that are given at the commencement of a civil trial. And that instruction is from Florida Standard Jury Instructions for civil cases. I think the court has already gone over with the jury during jury selection that this is not a civil case. And it seemed to me that there was nobody on the jury that was confused about that.
All right. I'm not going to give that instruction, but it's preserved and is part of your record.
Thank you, Judge.
Oh.
Same, let me just have a standing statement
Yes,
that
of
I
course.
ask the court to consider each sentence
If I
alone.
decline to give it.
Sorry?
If I decline your request, it's still over your objection,
Right, and then I've asked you to consider each sentence alone.
correct? Yes, you have it paragraph by paragraph, so individually and cumulatively for the subsection on criminal cases are different from civil trials. I'm not going to give that. Failure to exercise every possible precaution does not constitute recklessness or culpable negligence. And then we have is this part of the civil jury instructions?
It is.
Where I got
Okay,
the language.
all right, yeah, okay, I'm just double checking here. All right, I'm going to decline to give the requested civil instruction on failure to exercise every possible precaution does not constitute recklessness or culpable negligence.
And Judge, the court would, I just want to remind the court that the state has introduced evidence of all the things that George Pino could have done, even if not required by rule or regulation. For example, he could have had passengers wear life-saving devices. That's going to be the next one. You know, he could have had them sit somewhere else on the boat. He could have had the flares that are not expired. That's going to be a theme throughout, I believe, of the closing argument.
I
And
think you're going to make objections that you think are appropriate, if that's part of the closing arguments. But how the state, this is only one page. Oh no, okay. How the state would tie that in to their burden will be part of their argument, and then you'll make objections you think are proper to that
yes,
argument.
but unless the court sustains them and instructs, then I'm going to look like I'm making a frivolous objection. So if my objection is, you're expecting my objection.
Well, I might sustain and instruct. It really depends on how the argument is made, right?
Right, and so I anticipate the argument that they're going to make, for example, that none of the girls were wearing flotation devices, and then ask the jury to imagine maybe the decedent would have survived if she had a flotation device on. Perfect example. Not required by law, but the state's made that a feature of their case, and they're going to ask the jury to find the defendant guilty because he could have had her wear a flotation device, and had she worn one, we might not be here on a manslaughter.
I'm not sure that would be a proper argument.
That's why I'm asking the court now, rather than for us to have to interrupt the state to rule on that issue and properly instruct the jury or the state that that's not a proper argument.
Okay. Do you have anything you want to comment on?
I'm not sure I'm understanding what he says I shouldn't argue.
I think we're trying to kind of anticipate what closing arguments are going to be.
No, I understand that, but I'm not sure what he's saying that I can't say about a life jacket. I'm
Yeah.
certainly not going to ask them to convict him of these homicide charges because the girls on the boat were not wearing life jackets. I think, like many other factors in this case, that's a factor that the jury can take into account. There's evidence of it. I could
Take into account to determine what?
to determine if the defendant was either reckless and or culpably negligent.
Reckless in or culpably negligent in the operation of the vessel?
Yes, because he's got a vessel that has passengers on it, that if something terrible were to happen, they're not wearing life preservers.
Okay. So how is that
If you have a crash and you've got a baby that's not in a car seat, and the baby dies, would the
Okay.
prosecution be prohibited from talking about the fact that the baby wasn't in a car seat?
No.
And,
So-
you know, the state's not even permitted in a situation like that to say, oh, well, he violated that law, so you convict. But it's a factor that goes into the mix, just like it's a factor if the defendant had alcohol on board. Just like it's a factor how fast he was going. It's a factor of how much weight was on his vessel, what direction he was heading, what speed he was traveling at. All those things, the conditions of his passengers that were, some of them, you know, by their own testimony, were at a minimum buzzed. I think all of those things are factors in the way that this vessel is being operated, because it's not just where you're steering, it's who you're steering and who you're endangering. That all factors into whether or not you're reckless. And the Martinez case, Judge, substantiates that, because in Martinez, whether somebody's consumed alcohol or not isn't in and of itself reckless operation of a motor vehicle. But in the Martinez case, the Third District Court of Appeals said whether somebody had alcohol on board is a factor. It had nothing to do with the driving, but it had to do with the overall factual scenario that was taking place. And so if they can find that a person's consumption of alcohol, even if the state can't prove it was an unlawful amount, that's still a factor that the jury can take into consideration.
In determining whether or not the operation was reckless.
Correct, in a vehicular homicide case. So if we just transfer that onto the water, if one of the factors might have been that he consumed alcohol, okay, the third says that's okay. So let's look at other things that happened that endangered other people.
Well, don't you look to the actions of Mr. Pino, or the inaction of Mr. Pino, right?
Yes, and he's the
So
captain
the
of the
inaction of Mr. Pino in not requiring the girls to wear life jackets.
He required them to sit down when he started going faster. He obviously recognized that things were not going to be as safe once he started moving at a faster rate of speed. I'm not saying he's guilty because he didn't make them wear life jackets. I know there's no law that requires it, and that was made clear to the jury. But it's a factor, and I, feel like when we were litigating the sworn motion to dismiss, the court seemed to indicate by Your Honor's ruling that the court was understanding the state's perspective that this isn't just as simple as a speed alone case. And as I argued in the first JOA, where there wasn't much argument with the second JOA, but in a situation like this, it's the state's position that, yes, of course this is reckless. If there weren't all those girls on the boat, if the defendant didn't even have any alcohol on board, if all he did was operate his vessel at that rate of speed in that direction, where unless he deviated course, he was going to slam into that channel marker, and he didn't do anything, if his wife had died, if she was the only one on the vessel, if Lucy was the only one on the vessel, he would be guilty of vessel homicide, no two ways about it. But you have all these added factors that endangered so many people that, to me, it didn't seem appropriate to only charge the vehicular homicide, because this isn't just reckless. This is something more than reckless. It's in the level of culpable negligence. And the jury can make a decision if they agree with my decision on how to charge it or not. But, in terms of the arguments that go into the mix of what's reckless, what's culpably negligent, those were arguments that were made that it seemed the court was sustaining when it denied the motion to dismiss and denied both of the JOAs.
Judge, may I just make sure that we're distinguishing between, because I think the state's conflating conduct that affects the operation of the vessel versus inaction that could, had it been done, might have mitigated the consequences of the elision. So a life preservers, by way of example, has absolutely nothing to do with whether there would be an elision or not.
But it has to do with whether or not there could be a potential for death, and remembering that the instruction is that the operation means an intentional, wanton means with a conscious and intentional difference to the consequences and with the knowledge that damage is likely to be done to persons or property. So the consequences of that recklessness also means if you're passengers.
If you're not prepared, or you have your passengers prepared for what would be a foreseeable consequence of the conduct, then that is, from the state's argument, ties into viable evidence that the jury can consider.
That is their position, and that's just not a correct statement of the law, because now that they're imposing upon Mr. Pino a duty of extraordinary care, the law doesn't require a life preserver. That's the simple example.
No, I don't think it's extraordinary. I don't see it. I'm not sure I agree with that. Given all of the circumstances, choosing a course of conduct, in this case in particular, to go from point A to point B, there were certain decisions made, and the jury can find or not find that these were conscious, intentional, not in an evil way, but in intentional conduct, that it would be foreseeable that death or great bodily harm could result because of the actions or inactions of Mr. Pino.
So,
I think that's what I understood the argument to be.
So, you can't compare consumption of alcohol, which, if enough of it is consumed, it would impair the driver and affect the operation of the vessel, to, for example, failing to go beyond what the law requires and force the passengers to wear a life preserver, by way of example. The law doesn't require it, you'll see that's our next instruction, but the state will argue to the jury, apparently, that he acted recklessly by not having the passengers all wear life preservers. Had he not alighted, the life preservers would have had no relevance to this at all. Of course.
Okay, I'm not sure I understand what you're saying. I'm not sure that I'm not going to speak for, and I've already heard just a general summary of what the argument is. I'm sure there's going to be much more to the state's argument, and we're not, previewing closing arguments here, but and again, whether or not, and there was evidence presented about there were enough life preservers and they weren't wearing them, okay, and the evidence, if I remember, Mr. Pino had the girl sit down knowing he was going to increase the speed of the vessel. I don't know if that was the evidence.
No, I think the testimony was at some point he asked the girls to sit down while they go underway, which is the prudent thing to do. Okay. I think that the officer, the lieutenant, agrees.
Okay.
I don't know what.
And I don't know what it has to do with the speed at all, or whether or not being prepared for what could be potential consequences to the actions that were taken.
Well, it also improves visibility, because if the girls are standing, they would obstruct his visibility.
Okay.
So there may be two reasons why it would be appropriate to have the girls seated.
I guess you could argue that, right?
But I'm okay with that.
Yeah.
That one doesn't bother me, right? He has everybody seated and he's being prudent. No one's going to say he's imprudent by having them be seated. That's not the issue. The issue is these other have an engine cutoff switch.
Okay.
Not required. No relationship between.
Okay. But that doesn't go to what was relevant evidence, and the weight or significance of whatever any of this evidence was That's part of the argument, right? That the jury doesn't, your position would be, well, what value does that have at all to how Mr. Pino was operating or failing to operate the boat in an appropriate...
For some reason, in civil cases, the court gives this instruction.
Okay.
You would think if it's appropriate in a civil case, it would certainly be appropriate in a criminal case.
Okay.
And that's all. So they're going to argue that Mr. Pino could have done many more things to improve safety. We all could do more. The law just doesn't require it, much less allow that a conviction stand based on the failure to do more than that which is required by law.
Okay. And, all right. I am not going to give the failure to exercise every possible precaution does not constitute recklessness or culpable negligence, and then the fact that the Florida law does not require persons to wear personal flotation devices on vessels more than 26 feet in length. That is argument, and I'm not going to give that instruction. And the engine cutoff switch, let me see here.
I think it's undisputed the law does not require an engine cutoff switch under these circumstances, just like the law doesn't require anyone to wear a personal flotation device.
Right.
Our recollection is you told the jury you would be instructing on this. That's our recollection.
I think that has to do with the navigational rules.
My recollection is not as good as my colleagues. They recall that there was a point in the examination where I was trying to extract these points of law, and the court told the jury that you would instruct on those points of law.
I think I would tell the jury that I would instruct on the law. I didn't know. I don't know if it meant that on whatever you were discussing, I was going to instruct on what you were discussing. I sustained an objection, and I'll instruct them on whatever the law is. What you're asking me to do, though, in terms of the instruction, is not an instruction that I'm going to give in this case in terms of a special instruction. Okay?
Well, if we can find it, I'll let you know why that's our recollection, whether that changes your mind or not.
All right. And state if you see it, you see something, or you know something. If I made a statement to the jury with regard to the cutoff, it's cutoff switch, right?
Somebody called it a kill switch. Either way.
Okay. If I made a statement to the jury that I would be instructing them on what the law is on a kill switch or cutoff switch, I don't remember.
I seem to recall that on cross-examination, defense counsel asked Mr. Albert if there's any legal requirement to wear a kill switch, and I believe he said no. But we can double check the transcripts. But I think the jury already knows that that's not
The
a
jury
requirement.
knows that it's not a legal requirement.
Correct.
But whether I advise them that I would then instruct them,
I don't remember
I
that.
don't
but
remember. I'm not sure if it was in that context. Oftentimes I will say the court will instruct you on the
Right.
law, and I don't know if it was specific as to what the kill switch, what the laws on kill switch, what the laws on
Life jackets.
on life jackets. In terms of, I believe when we were discussing and I allowed evidence regarding the navigational rules, okay, I gave them an instruction over objection about the rules in general, that specifically advising them that a violation of any of those rules, individually or cumulatively, is not in and of itself evidence of a culpable negligence or recklessness. I think I gave them that instruction. over your objection, because I think the objection was that I should not have allowed any evidence of the navigational rules. I think that that's what occurred during the trial, which I allowed the state to introduce evidence of the navigational rules with that limiting instruction. And we're going to get to that in a minute, because then the state is asked as part of the final instructions for me to instruct the jury. And it's very similar to the instruction I had already given to the jury on how, if at all, they can consider the navigational rules. So I'll get to that in a minute, okay? In fact, I'm going to get to it right now, because this is the point to do it. Because next we would be talking about weighing the evidence. Okay, so.
Actually, Your Honor, the state had put in the jury instructions that I sent to everyone today that after Your Honor would instruct on the vessel homicide charge, that the next charge the state would be seeking was a charge on the navigational rules. And it's largely the same as what I had put forward previously.
And it has to, I think, and I agreed to instruct the jury over defense objection, and I think similarly in the final instructions there has to be a boundary or limiting instruction as to, so the jury is clear that a rule violation does not mean any kind of criminal culpability. It doesn't translate into either individually or cumulatively criminal culpability. So,
So on page 9 of the proposed instructions that I sent, I think is an accurate reflection of the case of Logan, which is at 592 Southern 2nd 295. Because in that case, the defendant...
So I'm not going to read the rules specifically?
No, I understand that, Judge.
I'm
only
asking you. You're not
for
asking me to read the rule specifically.
No, if the court looks on page 9, the request from the state is for the following instruction. In the state of Florida, the law requires operators of vessels upon its waters to follow the navigational rules. However, a violation of these rules is not sufficient by itself to constitute culpable negligence or recklessness. In order for you to include a violation of any of the navigational rules in your deliberations, you must also find that such a violation was accompanied by a thoughtless disregard of the consequences or an indifference to the safety of others and caused or contributed to the cause of death of Luciana Cristina Fernandez.
All right, now you've already objected, but can you look at the language that's proposed and
objection to the first two sentences, but then I do object to the remainder of the paragraph, because that's now the court telling them how to use these rules in their deliberation. And if the court is not inclined to rely on Third District Court of Appeal and other courts of appeal case law when we propose instructions on how to guide deliberations on the ultimate elements in the case, and so too.
yeah, I'm going to modify the language a little bit there.
If the court would prefer that, and the defense would prefer in order for you to include a violation, if both parties, I know the defense is going to object under any circumstances, but If it makes it less objectionable to remove that final sentence, I'm happy to do that. And the court just advised that although the law requires operators to follow navigational rules, a violation of these rules is not sufficient by itself to constitute culpable negligence or recklessness. Sorry. Then that's fine. I'll take that out.
I can just have a moment.
Because I think the less the better here, anyway, because it is a gray area, frankly. Again, not a standard instruction, and I need to make sure when I instruct the jury that there is a fair balance on, on not telling them how or whether they should, but just leave it as the simple explanation of they do not constitute culpable negligence or recklessness in and of themselves. So over the objection to giving a special instruction at all, I'm going to take out I'm just going to leave the first two sentences in that. Okay? Okay. Then I would have the reasonable doubt instruction. And that was just recently amended. In fact, we just got one